catch it over on YT. Because, honey, I don't want to be here all night. You know what I'm saying? Like, I love you guys. But I don't want to be all night. Okay, so I'm going to read. If you guys are new here, welcome. Make sure you guys tap the screen. Follow me. Because, well, I'll just keep you updated on all the juicy topics. Especially with this case, because I think for next week, we're halfway there to the, what is it, the day of the heart meets? I don't even know what it was. Baby daddy's in the house. What up, baby daddy? What was I gonna say? Tappers and yappers, just tap the screen. Thank you. I love a good kiss. When I'm reading the documents, you guys, I stay out of the comments though. So if you guys say anything, I'm not gonna respond to you. Yo, baby daddy. And if you gift me, I thank you. I may not see it, so I may not be able to thank you. So I just want to make sure that I let you guys know that. I love you though. Okay. How did it just get small? That's what she said. Just kidding. Okay, focus. All right, so this is respondent's reply brief to petitioner's 316 evidentiary hearing. So this is her reply to what I read yesterday. BRI's documents are always exhausting. Thank God it's Friday. And are difficult for me to read. Always. Okay. To the court and to petitioner and his attorney of record. Please take notice that Respondent Brianna Lynn Olson hereby lodges a reply brief to petitioner John Gacy's 316 evidentiary hearing brief, RE, the upcoming FC 3044 hearing scheduled for 4/2/26 at 1:30 p.m. in this department. The FC 3044 hearing was originally set for 1/6/26 at the conclusion of the 8/27/25 DVRO, but was continued and set as an evidentiary hearing per the request of John's counsel, Ms. Taylor Butnick, made at the 1/6/26 hearing. In preparation of the original FC 3044 hearing, Brianna filed and served pleadings on 12/31/25 and 1/5/26, with the former containing the FC 3044 analysis. But John did not file anything. At the last hearing, the court ordered a due date of 3/16/26 for the filing and service of pretrial documents for the 4/2/26 hearing. Since Brianna filed her FC 3044 pleadings months ago, John was able to respond to it in his 3/16/26 evidentiary hearing brief, but Brianna did not get the same opportunity, as she had nothing to respond to since John filed nothing before the first hearing set for this purpose on 1/6/26, and he did not serve his evidentiary hearing brief until after hours on 3/16/26 at 5:15 p.m. Thus, the purpose of this pleading is to take the same opportunity John got and responded to his 3/16/26 evidentiary hearing brief. Well, just turn your shit in. Like, what's the big deal? Weird. Okay. Requested orders. I want to go big. Oh, she also said that. Let me stop it. Okay. Request order. Brianna respectfully requests the court to order the following. Stop it. She has overcome the presumption. She hasn't overcome shit. How is she overcome? Like, I'm already irritated. How has she overcome anything? She hasn't even finished her damn parenting classes. I'll shut up and read. She has overcome the presumption against joint legal and physical custody pursuant to FC 3044, and an order for joint legal and physical custody is in W's best interest. Deny, in all capital letters, not even lying to you. Then all capital letters. Deny John's request to the contrary. Oh my God, she's so damn dramatic. That the presumption was not overcome. Additionally, deny. Again, what the fuck was with the deny in the capitals? Is that what you guys are talking about? What is with the deny in the capitals? This bitch is killing me. Okay, additionally, deny John's request for the FC 271 sanctions on the basis of bringing the instant motion before the court when it is factually impossible for the court to find that the FC 3044 presumption has been rebutted. This is a completely false statement in John's 3:16-26 evidentiary hearing brief to the FC 3044 hearing. Brianna never filed a motion for this hearing. The court set the hearing on its own motion for 1/6/26 at the conclusion of the 8/27/25 DVRO trial. Then John's counsel insisted this hearing not happen that day as scheduled and instead be calendared as an evidentiary hearing, a far more costly hearing type for both parties for a future date. The court setting this hearing, what the fuck is she talking about? The court setting this hearing is not sanctionable. What is she talking about? The court setting this hearing. I can't. I think she's trying to say the court said this hearing is not sanctionable, I guess. Anyways, this dummy. And then it says joint legal custody. Hold on, I gotta go to the next page. Oh my god, there's 21 pages of this shit. Oh my god. Okay, and then number 2, joint legal custody. Number 3, primary physical custody to John in Texas with visitation to Brianna with W for 2 weeks out of the month in California. Deny. If the court believes a step-up plan would be more appropriate, Brianna suggests visitations with W in California for 1 week a month for 2 months, increasing to 2 weeks a month beginning in June. After the 2 to 4 months on whatever schedule in California that the court deems appropriate, Brianna would suggest transitioning to something that is not so choppy as to travel for everyone, like 1 month in California with Brianna, and then 2 months in Texas with John, and keep that schedule. Isn't her attorney, okay, can you turn the comments back on real fast, Principal? Isn't her attorney a family law attorney? What individual who, whether you work with people or not, or children or not work with children, who on earth would ever suggest having a 2-year-old be with one parent for 1 month and then not with another parent for 2 months? Do you know how much trauma that is going to be on a child? No way in hell. That's crazy to me. Right. Yeah, in school. I mean, he's not yet. I mean, technically, because he goes to like a school or daycare, like a preschool, that's not required. So the courts don't look at that as much. But when he's 5, then he will be, because he'll be in kindergarten. But this is absolutely insane to me. Oh my god, I have to keep her. Oh my god, I already have a headache. We're only a page and a half in. I already have a headache. But I just want to get your guys' thought process on that. Is what do you guys think about the whole 1 month on, 2 months off? Missy, we just started reading Bri's rebuttal to 2K stuff, and she's saying that they have to deny his request, and she's asking for 1 month with Bri, and then 2 months with John, and then a month with John and 2 months with Bri. That's a mess. That's a mess. That should never happen. Okay, I'll go back to reading. I just want to make sure we're on the same page. That's craziness. Okay, oh god, not Brianna's mom. Jesus Christ. That lady has been in every single court doc. No one's seen her yet. No one has seen her yet. Anyways. Okay, so she would like 1 month in California with Bri, then 2 months in Texas with John, and keep the schedule on rotation. Brianna's mom can assist with flying W back and forth. Yeah, put him with somebody he doesn't know. That's a grand idea. We're just really thinking about W's best interest here. This is a bunch of bullshit. Sorry. The daycare John enrolled W in has locations in California. That doesn't, okay, I don't know if I'm going to be able to read this today, because that doesn't make a difference. You can't just take a kid out of one daycare and put him in another daycare because he's there. It's not this. Oh my god. Shut up and read. I can't get invested because this shit's pissing me off. Right, only in Bri's delusional world. Thank you, Jenna. Like, I can't, yeah, she has one. Where's she gonna take him on, or take him to? But you can't just take him to a different daycare. And again, for baby W, can you imagine? Now you're changing homes, schools, parents, friends, teacher, like everything. No, this is crazy. And if she capitalizes deny one more goddamn time, focus. Okay, let me try. I'm gonna try to just read through it because I'm gonna get pissed. We're gonna be here till midnight with me reading this shit. Okay, Brianna's dumbass mom who's never been around. She can assist in flying W back and forth. The daycare John enrolled W into has locations in California, so W can just continue to attend this facility during Brianna's time if the parties agree that would be appropriate. Deny John's request to reinstate supervised visitation with keeping the peace in Texas, as there is absolutely no basis for it. By COB, by close of business on Friday, 4/3/26, John shall provide access to Brianna to W's parent app and all the records at W's current daycare. Within 3 business days of the court order, John shall reach out to the organization he received the... I'm not... You guys know I don't go into any stuff about the kids, so he received a referral for W 2 months ago and scheduled him an appointment. Brianna cannot do this for him as they'll be visiting John's home for W. I know it's already out there. I never release any medical stuff on kids, so I'm not going over that. So John's scheduled appointment. Deny John's request to use the paternity case trial as a DVRO renewal trial. John must file and serve the DV-700, DV-710, and the blank DV-720 to get a DVRO renewal hearing date. There is a statutory process for this that John must follow, and haphazardly making this request by way of an evidentiary hearing brief is not it. Furthermore, should John proceed with this request, Brianna plans to file a dueling DVRO against... You've got to be shitting me. Brianna plans to file a dueling DVRO against John? For what? For ignoring her dumbass? For calling her a London? Because that's what she is? What do you mean? Brianna plans to file a dueling DVRO against John as to the continued harassment and direct threats that John makes himself towards her and says, Santos is not a part of the goddamn case. I cannot. And Santos Online, and that he directs, encourages, and or participates in with his business. Listen. I don't even talk to John. Okay? So he doesn't encourage, direct, or nothing over here. This is my wholehearted opinion. Personal and professional. She's a terrible mom. She had almost 2 years to pick this shit up. And she still has not. Oh, I can't. This is pissing me off. I honestly, you know what? Kudos to John for keeping his mouth shut, because I can't even, and I don't even know this poor child. Thank God W has John and Mama 2K. This poor baby. We're only on page 3 and I'm irritated. Oh my God. I can't. You guys, I honestly don't know how I'm going to get through this. Okay. Okay, so he continues to, John makes himself toward her and Santos Online, and that he directs, encourages, and or participates in with his business partner, good friend, ex-roommate, Chriso. Drop the ex-roommate bullshit. And then the other request is, Santos can be around during Bri's visitation with W. Lift the current order to the contrary. She's more worried about Santos being around than baby W at all. Like, it blows my mind. Argument. When finding of DV has been made within the last 5 years against a party seeking custody, Brianna, of a child shared with the alleged victim, John, a rebuttal presumption against giving the alleged abuser joint legal and physical custody applies pursuant to FC 3044. However, Brianna can't overcome this presumption if, by a preponderance of evidence, she shows that an order for joint legal and physical custody would be in W's best interest, and that showing is balanced with her satisfaction of particular criteria under this law 3044. The factors under 3044 that the court must consider are the perpetrator, so BRI must successfully, BRI has successfully completed a batterer's treatment program that meets the criteria, which she hasn't done. B, BRI had successfully completed a program for alcohol or drug use, if that was determined, which that was never determined. C, the perpetrator, or BRI, has successfully completed a parenting class, which she started but hasn't completed. D, the perpetrator is on probation or parole, which she's not. E, the perpetrator is restrained by protective order or restraining order and has or has not complied with its terms or conditions, which she has one and she has not complied. E, the perpetrator of domestic violence has committed further acts of domestic violence, which she has. Hold on, I gotta go to the next page. Okay, that was 3. So let me go to 4. G, the court has determined, pursuant to 6322.50, that the perpetrator is a restrained person in possession of control of a pew or ammunition, which they have video of her being around one. As outlined in BRI's 12/31/25 pleadings, most of these factors do not apply. And she has satisfied those that do. No, she hasn't. Where's the proof, Ms. Fonseca? Because I know you watch. Where's the proof? We know you're over here. Don't play games. First, there has never been a batterer's class ordered, as the court explicitly stated that the conclusion of the DVRO trial on 8/27/25 that ordering this class would not be appropriate since John requested a DVRO was never about physical abuse perpetrated on him or W by Brianna, but about the perceived, what he perceived as mostly online harassment and threats, and the court weeded out much of the evidence as irrelevant, as it was not a defamation trial. John's 3/16/26 evidentiary hearing, Bruce falsely stated John alleged physical abuse perpetrated on him by Brianna at the DVRO trial, but that never once occurred as reflected in the transcripts. Second, the alcohol and drug abuse counseling was never ordered, which we know that, and Brianna is not on probation or parole, we know that. So B and D do not apply. Third, Brianna completed a class voluntarily on 6/20/25 before the DVRO trial ever started. She completed a private 12-session course for high conflict co-parenting that was taught to her over Zoom by the owner of Cornerstone Counseling Center, ALMFT. She invited John to do the class with her, and he denied, which we all know. She filed and served her completion certificate on 7/3/25 and discussed these same details about the course in a supplemental declaration before the DVRO trial started last fall. The court's DVRO trial orders of 8/27/25 said that prior classes completed could count towards the class that the court ordered before both parties to take. At the time of the 1/6/26 hearing, John still had not completed a parenting class as ordered as the conclusion of the DVRO trial, so the court reaffirmed its prior order. Since the 1/6/26 hearing, John filed and served a completion certificate on 2/19/26 showing he completed a 12-hour high-conflict co-parenting class through online parenting program. This site does not offer live classes in person or online, but provides a self-guided structure through lessons posted online that one can just absent-mindedly click through. How can you absent-mindedly click through it? You wouldn't be able to have. Anyways. Brianna Santos her current boyfriend and father of her unborn child, she is pregnant with, enrolled with with Item Industries Inc. after the last hearing to take parenting classes together, not co-parenting classes, is what Brianna's last class was about. Oh, now she's all big about the not co-parenting classes when we were all preaching that the whole time. She kept saying, she's taking the parenting class, taking the parenting classes. Stop it. Her completion certificate will be filed and served before the upcoming hearing. In sum, Brianna took a co-parenting class voluntarily and will have completed a second class in parenting by the time of the hearing, satisfying C on the above. John alleged Brianna has not satisfied E, F, or G, and G, from the list above, which will be addressed in the following sections. Okay, I'm going to go to the next page. I. Messaging John. She has this in all look. All bold, capital, under. I can't see shit. Messaging John on OFW to talk about W's medical issues or ask about his day was in daycare are not DVRO violations, but regular co-parenting conversations, especially in a cross-country co-parenting relationship. Okay, well, I have to say a few things about that. You guys already know that. First of all, when did that happen? When did John file and say any of the message, or have on his evidence list or anything, that any of the messages from that or her asking about his day, when has John ever said that was an issue? That has never, that's never come up. Second of all, when the hell did California and Texas become cross-country? Like, I get that I went to school a long-ass time ago. Did California and Texas move? I'm genuinely curious. A cross-country... Artistically, level 6, thank you, love. A cross-country co-parenting? Literally. Cross-country co-parenting relationship. It's just like, right, me to New York, cross country, me to Florida. I would even consider like me to like Georgia, cross country. Maybe even some people wouldn't consider Washington to the Midwest coast, you know, maybe you're going to Chicago, whatever. But California to Texas, definitely not cross country. You can't, listen, I can get to Canada in like 2 hours, maybe 3 hours from where I'm at. West Coast, East Coast, cross country. Yeah. Okay. What happened to this? Why did it get dark? Okay. Let me continue. John's continued refusal to even acknowledge Brianna as his co-parent and respect her as such is highlighted by the allegations. John alleged that Brianna has violated the DVRO by messaging him on OFW about matters unrelated to her visit with W. The only messages that fall into that category on OFW are threads about W's a referral. Again, you guys, I never go into what they're talking about when it comes to the child. About a referral for services for W. And updates about W's daily life and daycare, since John still refuses to give Brianna access to the facility's parent app. As Brianna's counsel confirmed with the court at the 1/6/26 hearing from a call she personally made to the facility to confirm this information, only John can give Brianna access to the parenting app. The facility cannot. The DVRO contains no orders precluding Brianna from having access to W's records. And nevertheless, John and Ms. Budnick have both communicated numerous times in writing that they will not allow Brianna access to the parenting app. I wouldn't either. John has no ground to stand on as to the DVRO violations when Brianna is asking him for updates. She could otherwise see herself on the parenting app, yet John is simultaneously denying her access. Ma'am, all due disrespect, did you forget that John has full custody of this child? full custody. BRI has 0 custody. BRI has minimal visitation. She has no custody. John has full custody, 100% custody, which means he gets to make those determinations. When you lose full legal custody, that means that you don't now have access to that. His father has full 100% access to that. He gets to determine that. Your client lost that shit because she can't keep her hands to herself. And it's going to come out she's still continuing to abusing her partner she's with now. Irritating. Golly. Okay. They claim this was to protect W's privacy at the daycare, yet on 3/7/26, John was shooting content inside the facility and posted on Facebook. Listen, lady. The content that John posted, you can see nothing. You can see John and a book and a wall. There was no identifying factors. It's not like how BRI films outside and you see the whole name of the building that she's at or the whole address of the house. Thank you guys for the daily heart me's. I so appreciate you guys. That's crazy work. That's absolute crazy work. And again, he gets to do that because he has custody. BRI doesn't have custody. Oh, wait, what? Address Megan? I don't know what anyone said. Listen, I'm not staying up in the comments. If I do, honey, I'll never get rid of these. Or I'll never get through this. Okay. In one of his posts, the room he was in can easily be matched up to pictures on the school's website. Therefore, doxing his child's exact school location. I can't. When this post was immediately brought to counsel's attention via email, and Ms. Fonseca asked that the post be taken down immediately to protect the privacy of where W now attends much of his time, Ms. Budnick opined? What is she trying to say here? John had done, I don't even know what she's trying to say. She OPINED. John has done, oh wait, let me turn these off. Okay. John has done nothing wrong and he was not going to remove the cute video. Clearly, John's alleged privacy concerns about what Brianna's post REW does not go both ways. Hey, y'all. Discussing medical appointments and medical concerns and W's time at daycare certainly are not DVRO violations. These topics are part of regular co-parenting conversations. John cannot claim that his co-parent asking how W's day was in daycare or asking John progress through referral is. Again, John has not stated that. John has never stated that. That's not on any court documents, nothing. Now, if they've had that conversation, that's a whole nother thing. But it's not come through the courts at all. Right. But yet she put out the whole address. Stop it. Ooh, part of this is covered up. Oh, John has no ground to stand on. Brianna's asking for updates. Okay, got it. Nothing's covered up there needed. Okay. Let me take another drink. Sorry. Oh, no. Discussing medical appointments and medical concerns and W's time at daycare certainly are not DVRO violations. These topics are part of regular co-parenting conversation. It's also my spot. And John's... Oh, there. Okay, sorry. John cannot claim that his co-parent asking how W's day in daycare was or asking for progress through whatever. I feel like I just read this. Okay. John falsely states Brianna cancels FaceTimes with W. The court will see this is not at all what is is reflected on OFW. OFW is our family wizard. It's an app that parents use. Then turns around and says she is violating the DVRO by asking him how W is doing on OFW. This position is completely illogical. Brianna is certainly allowed to talk with her co-parent about the Yes, she can ask questions, but she should also be attending her FaceTimes. If she was attending her FaceTimes, maybe she wouldn't have to text John on OFW to ask how W's day was. Wouldn't she know if she attended her FaceTime? Or, I mean, shit, let's just throw it out there. Better yet, what if she went on a visit? I'm just saying. Just throwing it out there. Oh, God, I already know I'm going to need a drink for this one. Now we're getting into why Santos should be there. Yeah, you're right. FaceTime is not to talk to John, but the child can't really have a full-on conversation. So she would be allowed to ask him questions then about how his day was, or be able to ask, W, and then he can chime in, whatever. Okay, so number 2. Santos was not present for any of Brianna's unsupervised visits with Winter. Are you sure you want to say that, ma'am? Are you sure you want to say that, ma'am? Yeah, you guys, we'll turn the comment. Sammy, why don't you just turn the comments back off? If they can't keep it cute in the comments, we'll turn them off. Sorry, guys. Listen, I tried to keep them on for you. But if you guys can listen, I always tell you guys, keep it cute or be mute, okay? You guys aren't going to be over here running my mods ragged because y'all want to argue in the comments. We'll argue when I come out, okay? Yeah, I don't know that you want to say that, ma'am, because he was clearly there, and that's going to be tested too. But nonetheless, we'll let you live your life. Okay, so Santos was never present, Santos was not present for any of Brianna's unsupervised visitations with W in Texas. As the court confirmed at the 1/6/26 hearing again, there was never an order made at the DVRO trial that prohibited Santos from traveling with Bree to Texas for her visits with W. Brianna has also never hidden the fact that this had happened from John or his counsel, which dates all the way back to emails between counsel in October when Ms. Budnick began threatening her ex parte RFO on this topic. John's denied ex parte RFO that he filed in October is further evidence of the court's agreement with his position, as John argued the opposite in the motion similarly. There is no order precluding Santos from staying at the same Airbnb that W and Brianna used for their visits when the latter two were not there. What the fuck is she talking about? Nothing precludes Santos from staying at the same Airbnb that W and Brianna used for their visits when the latter two were not there. Why don't you say when W's not there? Latter two. Brianna always flew into Texas a day or two before her visits to get the rental set up for W, and there was nothing wrong with Santos being in her rentals during those periods with her, as long as he was not staying there when W was there with Brianna. And he never was. John has no evidence that remotely illustrates Santos was ever present during these visits. Ma'am! His evidence, called compilation of social media posts, is a string of clips, all from third parties, of Brianna and Santos' separate social media posts posted at different times on different days from the same rental. This does not prove Santos was ever present during Brianna's custodial time with W. Where do you think W was then at like 3 o'clock in the morning when Santos went live from... You guys weren't going to tell me my caller was in? When Santos went live at the same Airbnb and Bree was there, because you could hear him and Bree in that video. Where was baby W, ma'am? I decided to ask. Throughout the 316 evidentiary hearing brief, John repeatedly claims that Brianna failed to comply with John's discovery. This court's order orders, and on John's motion to compel, stating she provided no documents. Brianna did provide documents, as well as code compliant. Oh my God. No, she didn't, because if she did, I would have read that shit. She doesn't turn in anything. Okay, Brianna did provide documents as well as code compliant supplemental responses on time. The response was, no, I'm not going to provide it. That's all the response was. What do you mean? Which will not be attached here due to containing personal information, but will be introduced at the 4/2/26 hearing. Wait a damn minute. Ma'am, again, all due disrespect. So you filed this stating John didn't give you enough time, or give Bri or you whatever, enough time to respond. But now you're stating you're going to respond to something that was court ordered she provide in February. You're now saying you're going to give them on the date of the day you guys have a court hearing? How would they have time to review and respond? And I didn't go to law school. Oh my God, that's crazy. Anyways, just because John and his attorney did not like Brianna's answers, which were overly full of extra facts and explanations, which goes far beyond the requirements of the CCP as to code compliant responses, which all it said was, no, I'm not going to provide it, and this is why I'm not going to provide it, does not equate to Brianna not complying with discovery. She turned in nothing besides saying, no, I'm not going to do it. These repeated statements are intentionally misleading to the court. Oh my God, I can't. Number 3, Brianna has not committed further acts of DV, regardless of what you've seen. John argues that Brianna has committed acts of DV against Santos. So therefore, she has not satisfied F of the FC 3044 list above. While California courts have interpreted this factor broadly to include acts of DV against the alleged victim, the accused, Brianna, shares a child with John, as well as DV against anyone else, Santos. The analysis does not go backwards in time prior to the findings of DV. Based on the evidence outlined on John's 3/16/26 exhibit list, that is exactly what he is arguing, but this is not the law. John's 3/16/26 evidentiary hearing brief argues that the court cannot consider evidence of John's conduct in exercising sole legal or physical custody of W in the FC 3044 analysis, but the case outlined below from San Diego County in 2018 says the exact opposite. In SY Superior Court 2018, in examining this factor under FC 3044, the court noted that the analysis is whether the perpetrator, which would be Bri, has committed any further acts of domestic violence. That's what they said. The court's analysis focused on whether additional acts of domestic violence occurred after the initial finding, ID 3044 through 3045. Also, the court noted that the determination of custody is not to reward or punish the parents for their past conduct, but to determine what is currently in the best interest of the child, ID at 334. John will forever argue that Brianna kidnapped W in 3/25 and attempts to use that incident against her until the end of time. But this case holds that Brianna is not to be endlessly punished for her past act. Does she read the shit that Bri and his attorney send in? Ma'am, all of the shit that they're saying is abuse from Brianna to Santos. So if W comes to their house and Brianna and Santos are battling it out, he is then a victim of abuse, ma'am. That's the law. I don't know what the hell you're talking about. Jesus Christ. But this case holds that Brianna is not... Okay, I got that. Okay. This 2018 San Diego case involved two parents going through a divorce with a shared child. and evidence was presented of multiple instances of DV perpetrated by dad on mom, slapping her, grabbing her, forcing her out of the house, then locking her out, and an arrest of dad for DV, although charges were never filed. ID at 328. During the divorce case, the family court services evaluated recommended joint legal custody and primary physical custody to mom, with limited supervised visitation to dad to start. ID at 329. At the custody trial in 2017, mom testified that dad slapped her and pulled her hair frequently during disputes, and detailed a bad incident in which dad slapped her, hit her, pulled her hair. I can't see everything, but you guys get the gist. Based on evidence of mom's statements to the police and pictures of her injuries, the court made a finding of DV against dad for an incident in 2015 and applied the FC 3044 analysis to the custody and visitation dispute. The court found dad had rebutted the presumption because the court had no fear for the child's safety around dad with his family around. Dad was attentive to the child. Dad understood the child's development, and the child did not want to leave dad's visits, and mom had withheld access to the child for 3 months. Mom appealed. You realize that's not the same situation, right, ma'am? Talking to Bree's attorney. Definitely not the same situation. Anyways, like John in arguing in this case at him, mom is in this 2018 case argued to the court and probably relied on her conduct in withholding the child. That's why she did that case, is because the mom withheld the child. Oh my God. Sorry. Like John is arguing in the case at hand, mom in this 2018 case argued that court improperly relied on her conduct in withholding the child because the preference for frequent and continuous contact with both parents cannot be relied upon in an FC 3044 analysis. In this case, John is seeking to have all evidence of his wrongdoings excluded, as well as not enrolling W in stuff, not telling Brianna nor involving her in any way in his decision to enroll W in daycare, then waiting until 12 hours before W was scheduled to start to even tell her on OFW that W was enrolled, continuing to openly harass and threaten Brianna and Santos on the... It blows my mind with adding Santos in there. Directing and allowing his good friend... How are you going to prove that he directed and allowed? First of all, Chris is a grown-ass man. Chris Different is a grown-ass man with his sledgehammer. But anyways, he's not stop it. Anyways, you guys know what I'm going to say. Directing and allowing his good friend / business partner / 2025 roommate. Oh my God. Chris Different with the sledgehammer, to make explicit threats to Brianna and Santos online. John does not get to bury his wrongdoings, as this 2018 case held this sort of evidence is directly relevant to the FC 3044 analysis and issued. Thank you, Dana. The appellate court disagreed with mom, noting the lower court's conclusion was sound, that mom's withholding of the child from dad was relevant. First of all, I'm sorry. I know you guys hate when I keep stopping. John's not withholding visitation. Bree gave up visitation. So I don't know how she's gonna conclude that. John is not withholding baby W. Bree gave up her visitation. Remember, we just read the last court docs? And at the beginning of the court case, the very beginning of the day, it was only like a 3 or 4 hour day, right? At the very beginning, Bree said, I'll travel both ways this month to Texas. I'll travel both ways. Next month, I'm asking, can I travel one way and John travel another way? Once Bree found out that W couldn't come to California, all of a sudden she was high risk. In that 3 hours, she became high risk and could not travel and said, I will not be doing any more of my visits in Texas. I'll have a FaceTime visit. Bree's words. John didn't say you couldn't come. The judge didn't say you couldn't come. Nothing. Bree said, I'm not going to come. But if you were truly high risk and you couldn't travel, you couldn't lift your bags or whatever, how is it you were going to do the travel the first time? So this case, again, doesn't really apply. But nonetheless, the mom's withholding of the child from dad was relevant to determining if awarding custody to dad would be detrimental to the child's interest. The court found mom's behavior reflected a lack of understanding of parenting practices. Like Bree. As this case makes clear, the exact evidence John seeks to exclude per his recent motion in limine is directly relevant to the FC 3044 analysis and was evidence explicitly invited by his court to be presented at the 1-6 hearing. The court also found that FC 3044 did not prevent the lower court from considering the child's need for a meaningful relationship with his dad. John is trying to mix and muddy the frequent and continued contact prohibited under FC 3044 analysis with these other factors like his poor conduct and W's something. Oh God. Which one is I just on? Okay, it's the next one. In his decision to enroll W, I think it says into childcare until 12 hours before W was scheduled to start, or even till, oh wait, I just read that one. Okay, I'm here. John is trying to mix and muddy the frequent and continued contact prohibiting, oh, we just read all that. Okay. As the court explicitly noted in the DVRO in this case, there was no safety concerns as to Brianna being with W, which is why the professional monitor was removed. W is happy when he's with his mom. He's happy when he's with his mom. She takes him everywhere. Like out of state. Like out of the Dallas County and surrounding counties. Takes him to San Antonio. Takes him where she's not supposed to. Sorry. She takes him everywhere with her and lets him experience things. She takes care of him by herself without help. W has never been harmed while under Brianna's care. These are all relevant factors to the analysis at him, as are John's bad acts as outlined above. Similarly, John argues that Brianna's pregnancy that limits her ability to travel relates only to the frequent limits her ability to travel relates only to the frequent and continuous contact argument. It does not. Being halfway through a high-risk pregnancy while living halfway across the country is a real-life hindrance to maintaining her relationship with W if visitations may only be exercised in Texas. Or her ass could just move to Texas if she wanted a relationship with her child. This is just the reality of the cross-country shit is killing me. The cross-country co-parenting relationship, not a frequent and continuous contact argument. Oh my God. The court's finding of abuse in the SY versus Superior Court case was made against Dad on 8/29/16, and the custody trial was on 10/12/17. At trial, Mom alleged that Dad had continued to harass and threaten her after the DV findings was made, and these were forms of whatever. Again, with the exception of the 1/5/26 verbal dispute clips between Brianna and Santos that John is calling evidence of new DV, all the other clips he offers for the same purpose perpetrated on 8/27/25 findings of DV, and therefore are not relevant to the analysis at hand. Hey, Betty. So we'll just skip all of the abuse that happened after court from the day it was set, moving forward. All the abuse that's happened from Bree to Santos, we'll just forget that because fuck it. Just fuck it. Why not? She wasn't pregnant at the time, so I guess it doesn't matter. It only matters. It's only DV if you're pregnant at the time, I guess. I wonder if she got her law degree like out of, remember back in the day we'd have the Cracker Jack box and you'd like dig down to the bottom to get the prize. That's where she got hers. I get so irritated reading these. And again, Debbie's not even my grandbaby, but it just pisses me off. Just like the 10/11/25 video counsel got to show in court at the 1/6/26 hearing without serving the evidence to Brianna's counsel prior to the hearing. The clip of John's exhibit list do not match their titles. The court kept asking Miss Budnick after watching that clip if there was more, and Miss Budnick had talked the clip into something it just was not. And the clip on John's most recent exhibit list are no different in character. There's something over this I can't read. The court something found none of the incidents alleged likely would have led to the issuance of a DVRO, and noted the parties' continued inability to cooperate did not amount to a new DV. The court also noted that the child was not privy to any of the alleged harassment or threatening incidents Mom claimed Dad perpetrated on her, and thus the child's health, safety, and welfare has not been put at risk. Bitch. Has not been put at risk? Did you forget that she left baby W on a bed? I gotta turn this back off. On a bed in the middle of the night to go make a fucking diss track at a bop house, the MILF house, the bop house, whatever, with a bunch of cokeheads? He hasn't been put in any type of danger at all. Did you forget that she took baby W out of Dallas and surrounding counties and took him to San Antonio and left him with people he doesn't even know? Just because he may not have been at risk, how would we know? He doesn't know those kids. That's still at risk in some way. You left a child with people he does not know. That's terrifying. This is the same bullshit of her saying, oh, well, we also have a kinder care out here, so I can just take him from there and just drop him in this fucking kinder care, and then you can just pick him up and drop him back over there, and he'll just be fine. No, the fuck he won't. And having him here for a month and here for 2 months. They're trying to mess the kid. Oh my God, this just irritates me. I tell you, Jen and John have a lot of restraint. As a grandma, no way would I be able to keep my mouth shut. No. I can't keep my mouth shut now. That had everything to do with me. Here, W was not present during any of the incidents John labeled DV between Brianna and Santos. Oh, so it's just okay. You can just beat the shit out of anybody if the kid's not there, I guess. 3, 6, 9, 9. 3, 6, 9, 9. Okay, let me see. Or is I just out? Okay. Evidence and testimony will show that Chris D, it's Chris on here, was previously a resident of Florida before he moved in with John. W and John's mom, my BFF in my head, into John's home in Texas in the spring of 2025 to work on he and John's latest business venture, a demolition and rebuild of multiple residential properties. The company behind this project, Different Development LLC, was registered with the Texas Secretary of State on 4/4/25 to John's then address. Chris D. then received the general contractor's license needed for this project on 6/17/25, and he and John started posting on TikToks about the demolition. And then the new build started in 7/25. Can we just clap it up for a second? Sammy, can you turn our comments back on real fast? Can we clap it up for John and Chris D? Chris D with a sledgehammer. Let's clap it up for them, because yeah, they could just continue to sit on social media and just make videos and battle and do, but instead they've taken that money and they've invested into stuff. They are growing. They are maturing. They're not just going to be on TikTok for life. What has BRI and Santos done to try to develop themselves to grow outside of doing their spicy page? Should listen to View. Spicy yucky. Okay. That's crazy. I don't know what got pregnant. True facts. That is true. Yeah, so clap it up for John and Chris D. Kitty! He's 16, love. Sweet 16. That's amazing. I'm so proud of them. I don't know why she's detailing it all out, because it definitely doesn't make them look bad. What is a 304? A hoe? Or do you mean the 3044? If it's a 3044, that's a DVRO trial. A 304 is a hoe. We used to do that us back in the day. We would type it out on the calculator, and then you turn it upside down. 304 would spell hoe. Hey, guys. Okay. Chris was still living with John and W during Brianna's 11/25 visit week with W in Texas, as he left comments on clips of a video of Brianna and W at Peppa Pig's World of Play, saying that W was not having a good time with his mom. And he knew this about W when a stranger questioned him on it, because he was living with W. Wait, what? Ma'am, you do realize all of us know that W's not having a good time when he's with his mom, right? 2K and Mama 2K must have a big-ass house for all of us to be living in there. Because if we all can just watch a video and see that W is not having a good time with his mom because he doesn't know who she is, that means that's what equates to us living there? Well, Red Rover, move on over, because I'm coming in. Like, what do you mean? Is that what she's trying to say in this stupid statement? Chris was still living with John and W during Bri's 11/25 visit week with W in Texas, as he left comments on a clip of a video of Brianna and W at Peppa Pig's World of Play, saying that W was not having a good time with his mom. And he knew this about W when a stranger questioned him on it, because he was living with W. That's her conclusion to how long Chris was living with. Am I reading that right? So that's how she's determining how long Chris stayed there? I've never met them. I've never been to Texas, but I've surely not been to their house. And I can tell you that he's not having a good time. She needs to be around him more often. She needs to, be in regular contact. I've told her many times, get one of those books where you can record yourself reading it to him so he can hear your voice. Get him a teddy bear that, he can squeeze the hand and he can hear your voice. All different things so that he knows. Unfortunately, I guess, now, W is now an afterthought. Everything is about Sunday, the baby, whatever. Hey, what's up? And it's just not about W. It is. Okay. Chris D vacated John's home sometime in 12/25. Brianna's exhibits KLR as to Chris D were all social media content posted by Chris D while he was living with John and W. As to the recent influx of direct threats from Chris D made to Brianna and Santos online, captured in another handful of Brianna's exhibits, John seeks to exclude, which have occurred since he left John's house. So how the fuck does it affect the DVRO? That's mind-blogging. which have occurred since he's left John's house. Evidence and testimony will illustrate that John either directed, encouraged, or what is this one? Maybe participated in these threats, which is extremely problematic for his position in the 3044 analysis per the case. How is she going to prove that? Is John back there like, ready, action, go? What do you mean? Oh my God. He's got to curse his head. You better say this, I swear to God. Stop it. Oh my God, I can't. While Chris D and John are not in a relation. What is she trying to play? While Chris D and John are not in a relationship and recently stopped living together, this is someone who John works with, streams with, and spends time with almost daily, according to what they both post online. John cannot point fingers at Santos while bringing someone like Chris D around. Bitch, you did not just compare Santos and Chris D. You did not just compare Santos and Chris D. There is no comparison. There's no comparison at all. I saw a clip yesterday where Santos is saying if either one of them even say something to him or get near him or whatever, he in the head. Stop it. Does she like just believe everything she says? I wonder. Wow. That one's mind-blowing to me. Oh shit. Wait, where's that here? Wait. Did I miss one? Sorry, guys. Oh, yeah, I did. Okay. Pursuant to SY versus Superior Court to show Brianna has committed more acts of DV, John must present evidence of DV that occurred after the 8/27/25 findings of DV were made. Almost all of John's evidence list of alleged DV between Brianna and Santos predates the 8/27/25 findings of DV. What are you talking about? No, but oh my God, I'm gonna pull up his evidence list. Remember this statement, you guys, because now she really has pissed off. Almost all of John's evidence of alleged DV between Brianna and Santos predates 8/27/25 findings of DV against Brianna. What about the all the October cases? There was right, exactly, Rachel. Thank you. Her punching him. I can't in October. Similarly, this evidence was not part of John's DVRO trial evidence. It wouldn't need to be because it happened after the trial, dum-dum. That's how the shit works. You get a trial, you go and you get it granted for 1 year, right? Then you have in that year, if more shit happens, then you can apply to get it extended. It would have to happen after the date. So first she's saying it didn't happen after the date. Now she's saying, oh, well, it did, but oh my God, I cannot. My anxiety is too high for this today. Similarly, this evidence was not part of John's DVRO trial for evidence, which is also telling. Yeah, how could it have been part of his thing when it happened after? Considering Brianna and Santos were already a couple at the time of the trial, and custody and visitation of W were issues on the table for that trial. He brought this shit up then, and he was told Santos is not a party of this case. He first had to have his granted. Now that he has his granted, he can now verify that there's DV in the household between Bri and Santos. So it's not safe for the child to be there. I can't. Since this FC 3044 factor is looking for evidence for further acts of DV committed after the finding of the DV 8/27/25, John's exhibits 3, 5, 6, 7, 8, 9, 10, 25, and 29 should all be excluded from use at trial, as these exhibits are all from dates before the DVRO findings were made. The only remaining exhibits on this topic are 16, 17, 19, 21, 20, 21, and 22. Well, first of all, that's a lot of fucking exhibits to prove that she's continuing to abuse people. What do you mean? That only leaves 16, 17, 19, 20, 21, and 22. Six different times of abuse. Which are all from the same argument between BRI and Santos on 1-5 and 1-6, not 2 days of arguing, but started close to midnight on 1-5-26 and then went past midnight. Okay, so what about the ones in October, the one in September, the one in November? What about all those? We're just throwing those out too because you think that's after August. Most importantly, all of these exhibits are inadmissible hearsay, as Santos is not even a named witness in John's exhibit list, and it is mostly him talking in these clips. Additionally, a couple having a verbal argument is not DV. How did he get a black eye? From her bad breath? What do you mean? Let me just read. Shut up and read, Angie. Furthermore, this argument was fueled by Brianna's pregnancy hormones and stress about the court hearing the next morning on 1/6/26. John has no evidence that Brianna has committed further acts of DV since a finding of DV was made against her on 8/27. Number 4, Brianna is not in possession or control of a firearm. John alleges that Brianna has been in possession or control of a firearm in violation of the DVRO. FC 6389 requires the court to order the respondent on a DVRO to relinquish any firearms and ammo in the respondent's immediate possession or control, or subject to that person's immediate possession or control, which makes clear that possession and control is distinct but related concepts. California case law has consistently held that possession of a pew-pew and ammo requires two things: knowledge and dominion of control. In People versus Bay 2019, the court noted that possession of a pew-pew and possession of ammo are general intent crimes that require knowing possession of the prohibited item. Furthermore, implied in the crime. That was number 9. Okay, 11. Oh, here. Okay. Okay, furthermore, implied in the crime of possession of a pew-pew is that the person is aware that the item is in his or her possession and that it is a pew-pew, and that it is true as to and the same is true, as to the probation condition prohibiting possession of a firearm and ammo. Whatever. Here, John's evidence of Brianna being in possession or control of a pew-pew comes from an 11/11/25 Instagram reel Brianna posted inside of a gym/game room in a workout bodysuit doing workout moves in front of Santos to a song with workout in the lyrics. Brianna is facing the camera or Santos the entire time with the ping pong table behind them. A clipper reposted this video to TikTok circulating something on the ping pong table in the room, which appears to be a prop pew lying next to the dumbbell and a ping pong paddle. Brianna and Santos never touched the ping pong table or anything on it, including the prop pew. Now it's a prop. And do not even look in that direction. Brianna will testify that this was a video shot in a content house in Texas that she and Santos made content in with other content creators, most of whom they did not know personally. The room they were in was a content room with gym equipment, a pool table, a ping pong table, black walls, excessive lightings, and mirrors where the two of them and others throughout the day were making content. The other evidence that John has to support his claim is a clip posted by a third party of a live stream of Brianna's in which she addressed the allegations about the pew-pew. She alleged, an allegation created solely by these clippers online, not even by John, explaining she did not even notice the prop. How, if she didn't notice it and didn't know it was there, how does she know it's a prop? Genuine question. How would she know it was a prop? Anyways, explaining she did not even notice that there was a prop gun there. She was shooting content in a shared space, and that she would obviously be in jail if she ever touched a pew-pew. How does she know it's... I'm confused. I want to know how she knows it's a prop. She didn't know it was there. She never saw it. She didn't touch it. Anything. How does she know? Yeah. Okay. John cannot meet his evidentiary burden on this one under California law that with the evidence is holds. What? John cannot meet his evidentiary burden on this one under California law with the evidence is holds. This is why I have trouble. Brianna never had possession of the prop gone. Oh my God, this lady. Jesus. Is holds and then the prop gone. Brianna never had possession of the prop gone. We don't know how it was a prop gone. It's gone now. We don't know. I don't know if it's real or a prop. No, I cannot. Prop gone. G-O-N-E. This lady. As she did not even touch it or even look in its direction or even notice it was there. She just knows it was a prop gone, but I didn't even know it was there. That's so crazy. Furthermore, a prop gun is not a real pew-pew or ammo, nor something that could be argued as such, like a paintball pew-pew or a BB pew-pew. Brianna's presence in a room of a shared space where someone else's prop pew-pew happened to be lying next to other random items that were likely gym-related content props, not to constitute possession of a pew-pew or ammo. How would a prop pew-pew be other items related to working out? Who works out with that? Okay, let's move to number 5. I need some Advil. This one's ringing piss me off. Okay, number 5. Brianna has not violated the DVRO. Dum, dum, dum. Literally. This is very exhausting. At the end of the 8/27/25 DVRO trial, when the court was trying to set logistics orders for Brianna's unsupervised visits with W in Texas, Brianna requested an allowance to include the Corpus Christi area, and she was told no. Same thing with San Antonio. She was told no. End of story. The fuck do you mean? Sorry. She is from that area. We don't care. Sorry. She is from that area. Still has family there and could stay with a relative during her visitation instead of having to pay for a rental every time. Did she give a shit when John and Mama 2K had to do it for 8 months? They stayed in California for 8 months. It was 6 to 8 months. I don't know for sure. Never left. Stayed there the whole time because she couldn't even uphold her 2 weeks. She could not even uphold her 2 weeks of visitation. So John and Mama 2K could not go home. They stayed there the entire time. And now you're worried about it. And mind you, when Santos was in here, not sitting on his circle crisscross applesauce with his listening ears, just jabbering his gums, and she came in when I told her, it would be better for her to rent an apartment. It would be the same cost to rent an apartment as it would be for the Airbnb. And she said, I don't have to, bitch. I can have my visitations in California. Well, how's that working out for you, Brie? How the fuck is that working out for you? Don't complain about the cost then, dummy. Anyways. She is from that area. She has family there. Blah, blah, blah. She can stay at a place today. Okay. Oh, Miss Budnick argued against this idea, as she should, noting that this area was only accessible by plane from Dallas. By car, it's a 6-hour drive, and her client opposed any location in Texas that would require a plane ride. Thus, the court set the parameters for Brianna's visits to be Dallas and surrounding counties. But the latter was never defined. Bitch, surrounding counties is a county that is, is a county that is touching Dallas County. John even sent her a message and listed what counties they were and what area they were touching. What do you mean it wasn't defined? Dumb and dumber on this trial. Shit. Since professional monitor requirement was lifted at the conclusion of the DVRO trial, Brianna was free to move about with W during her custodial time, but has to make sure John was given the address of where she would be staying at least a week in advance on OFW. She followed the notice requirement before every visit. Exercise followed the DVRO trial, including the Christmas week visit. Did she? Brianna did not leave with W with random men, as John has accused her of on OFW and online. She left him with random men. The police officer saw that and stated it. John messaged Brianna a single time on 12/25/25 on OFW at 8:37 a.m. CST, asking how W was doing. Brianna did not open the message until 7:04 p.m. CST. Understandable, as it was Christmas Day, and not in a violation of any order, as she was checking the app at least once every 24 hours. By the time she saw John's message at 7:04 p.m., the police had already been called by John's mom, not him, excuse me, at 4:50 CST, and it conducted a welfare check on W at 4:56 p.m. CST. First of all, shout out to them for being there so fast. The call was made at 4:50 and they were there at 4:56. That's what I'm talking about. Yeah, the officer said that he showed up and he was able to place eyes on baby W, and Bree was nowhere to be found. He was there with her family. Right, Jimmy. Yeah, just randomly, he's just going to put his whole self out there just to protect somebody you don't know. No. So he conducted a welfare check on W at 4:56 CST. It is worth noting, this was the only attempt John made to reach out to Brianna all day before his mom called the police, which tracks with how he handled the 3:25 incident as well. He only reached out to Brianna a single time to ask where W was before filing an ex parte, accusing her of kidnapping him and making a public spectacle of him flying to LA to rescue his son. Bitch, he was already in LA. On the same day, he dropped a new song and music video, which was simultaneous. Okay, first of all, this dumb lady, you realize when you're a bigger creator like John, he has management. His management very likely did all of that shit for you. Even me, dumb over here that doesn't know how to work shit, I even figured out how to now drop like video, like I can record a video and I can have it set to be released in the future. Music is, when it's dropped, it's done at a certain time. Anyways, and why would he need to make more than one attempt? Why didn't she answer? On the same day, he dropped a new song and a music video, which he was simultaneously promoting by steering mega social media traffic to his page over the kidnapping narrative. You realize that we knew about the kidnapping stuff because Bree went live back in California with the baby. Stella was the first one to call it out, and as soon as people heard it, that's how everybody knew. That, what do you mean? Oh my God. John accuses Brianna of concealing W's whereabouts. She did. What do you mean? She did. They made Stella get off live as soon as Stella said something about it. She did conceal his whereabouts. Anyways, John accuses Brianna of concealing W's whereabouts, yet John did not even ask where W was on Christmas morning in a single message he sent Brianna the day before. Oh, wait. Okay, John messaged. Oh, here, up here. His pleadings also, okay. A single day before his mom called the police. His pleadings also falsely states he requested a welfare check, yet his mom called the police, not him, for some unknown reason. Who gives two shits who called? If I'm concerned about my grandbaby, I'm calling. The accusation that Brianna was trying to access John's address through counsel is false. Attached as Exhibit A is the 12226 email thread counsel was referencing. Mrs. Fonseca was providing Ms. Budnick with Brianna's new address and asked why John had never updated, filed, or served his UCCJEA form as required by the CRC for his prior moves. During the 525 and 825 pre-trial times period, Ms. Fonseca, which is Bree's attorney, was talking about there was not a DVRO in place and John was broadcasting to the internet beginning in 525 that he had moved. Yet he never gave Brianna his new address, nor updated the UCCJEA form as required by law. The UCCJEA form is if a child moves, you put that in. Why this was particularly bothersome was not over a care to know John's address, but that this was another example of counsel not allowing court rules. The former concerning example was counsel not following service laws as to any of the orders she attempted to serve to Brianna following Brianna's loss of her attorney in late 2024, with particular concern over the lack of proper service to the initial 325 ex parte service that led to the later debacle that month. The same one that she had that she read online that she knew about. I get it that she was not properly served. Listen, we will all be pissed about that one little thing. We will all be pissed about that forever. But nonetheless, she knew about it. Ms. Fonseca pointed out that John also never filed or served a UCCJEA form for his prior move when this minimally should have been done in October of 24. Ms. Budnick responded by threatening a motion of sanctions against Ms. Fonseca, then soon thereafter filed John's updated UCCJEA form. Now we're going into the emails. Pray for me. Let me take a drink. Right. Yeah, John, don't bring up nothing. I'll jump. We're going to go back to 2024. Oh, thank you. Start at the bottom. Okay. Oh, I'll tell you. Okay, let me see. Hold on. I have to go to the bottom. We're on page 14 of 21. So now I need to go to the bottom of the email. Let me see. Okay, give me a second to figure out these dates here. Oh my God, all the dates are crossed out. Let me see if this is going to make sense. Okay, I'm going to start at the bottom. Let's see if this makes sense. I don't know. Hi, Taylor. So this is from Bree's attorney to John's attorney. Hi, Taylor. My apologies for the delay in sending you Brianna's new address. I totally forgot about our hearing because I started 2 back-to-back trials right after that hearing. And today is my first day past that chaos to start catching up on office work and emails. The address is whatever. And the lease is attached that we had for you in hard copy format at the court hearing. I've mentioned John's lack of disclosure of his address in numerous emails and haven't received a substantive response. We know from his announcement made online that he has been in his house since 5/25. Is there a reason this address was never provided to Brianna or the UCCJA form that wasn't updated? She has a right to know where her son sleeps at night while in John's care. This is from Taylor back to Lindsay. Thanks, Lindsay. Please also file and serve Brianna's updated UCCJA declaration. Disclosure of John's address is not required. In fact, your request for same arguably constitutes an effort by Brianna, a restrained party, to obtain the address of a party protected by a DVRO. See attached Family Code section 6252.5 and the DV 130. Exclusion of all attached forms. Please refer to item 11 on the DV 130. Amen, Taylor. Listen, Taylor be clocking it. Love it. Okay, now go to the bottom again. Okay, we're good. Thank you guys. Whoever told me to go down to the bottom, thank you. Okay, so this is, no, I'm gonna go here. To Lindsay, what's your argument on the 525 to 825? Wait, how come I only see part of this? What's your argument on the 525 to 825 time period? What part of the temp order is in place at the time of John's move? Not even a stay away order, as we know, allowed him in. Hold on. Oh, I'm missing part of that one. Okay, well, that's okay. Okay, this is from Taylor. Hi, Lindsay. John isn't providing Brianna with his address. The law especially protects him from that disclosure between May and August. He was protected by the DVRO. Sincerely, Taylor. Here she goes with her fucking book again. So you believe number 8 on the 327.5 temp DVRO excludes the legal requirement on John per CRC Rule 5.52b, filing and serving an updated UCCJA form promptly when he moved? It doesn't. And you know there's the confidential address option for those that hold DVROs. So again, why did John move over 8 months ago, but has yet to file and serve an updated UCCJA? Huh? He also never filed one before that move to reflect his prior address. The only address he listed for W was Brianna's old address where she lived after giving birth. He minimally should have filed an updated form when the court entered the party's stipulation and ordered in 1024, but your office neglected to do so. On what basis was the choice of you to do that based on? Before you make another threat. Ooh, I can't wait to read Taylor's response to this. Oh, that's been crazy. Before you make another threat about this being about Brianna's violation of the DVRO, just know it has nothing to do with that. But with the repeated instances we have, like, thank you, love. Instances we have, wait, where is that? Sorry. Instances we have, like, things cited above on John behaving as if he's above the law. Shut the front door. He behaves like he's above the law. However, in his defense, this one really isn't on John. He doesn't know what the CRC says, but you do. Don't. Please advise. Oh, honey. Y'all get your drinks, okay? It's getting good. Oh, I gotta read Taylor's response. Get you a drink. Get you a snack. Come on back. Let's figure this out. Oh, my God. Oh, no, I need the whole response. Wait, where's Taylor's response? Okay, I just read that. Oh, you ready? I love how it's always short, sweet. Oh, thank you, love. I love how Taylor's are always short, sweet, to the point, and it's just like a punch in the throat. You know what I'm saying? Okay, let's see. Hi, Lindsay. What are you trying to accomplish? She said, what are you trying to accomplish? There is a permanent, bitch, not a temporary. There is a permanent, okay, restraint order in place that protects my client from disclosing his address to your client. Give me some good hit. I need that. The TRO that was previously in place similarly afforded him the same protection. If you want me to research how to file an updated UCC JEA declaration that keeps his address confidential for Brianna, I will look into how to do this. Taylor. That's what she said. Oh, wait, hold on. No, okay, I got it out. Let me go to the next page. Okay, here we go. And here's her book. Okay. And when Lindsay does an email, she never even says, hi, Taylor, or she never addresses it. She just goes, right, this guy. I gotta block this guy. Yeah, turn off. Okay. She just starts right with her thing. Again, if you read my last email, I provided you with a CRC rule. Like, we trust you. Like, we believe you. Okay? Anyways, updating the UCC JEA form when a parent moves and asks on what basis you failed to do this from 1024 when the party stipulated to the first set of orders to 325 when the temp DVRO was in place. Pause right there because I just thought about this. If she even said in her own email, Bree's attorney, it's not John's fault, his attorney should have done it, why is this being brought up then against John? Blows my mind. Anyways, you responded by talking about the present, asserting that a 1-year-old DVRO in place. That's not the period my last email was asking about. Why do you want him to file something that's no longer... So you want him to put in a UCC JEA form from an address he's no longer at? I'm confused. You responded by talking about the present, asserting there's a 1-year DVRO in place. That's not the period my last email was asking about. You were required to update John's UCC JEA form and file and serve it on Brianna and her attorney when John took primary custody of W in 1024, but you failed to do so. You seem to be basing this failure on the current DVRO or the 325 temp DVRO, both of which weren't in place in 1024. So you're not responding to my question similarly on purpose. Like with your lack of drafting and service of the 324X. Oh my God. No, I do kind of get it here, right? Because she should have drafted and served her properly, right? We would all be in a different situation. We'd all be in bed by now. But nonetheless, like with your lack of drafting and service of the 324 ex parte orders on my client, then your filing of a kidnapping RFO based on the undrafted orders. You seem unwilling to answer for your failures to follow law. I guess you're giving me your answer. First of all, again, all of that, though, is against her and not John. The attorney has to file the UCC JEA forms. The attorney files the orders and does the delivery of the motion. None of this has to do with John. So I'm confused on her issues. Okay. Let's go to this one. Oh, it's getting good, y'all. It's getting good. Okay, hold on. Wait, hold on. I need to see Taylor's response to that. I need it. It's not all there. Shoot. I'm going to try to read what I can. Something follow the law. It's not true. And it's petty and unnecessary, particularly when your hands are not clean. As to this issue, I don't know what she says above that, though. Your client has never filed. Oh, that's what she's talking about before. Okay. So she's probably just saying, listen, you don't have to do that, whatever. Your client has never filed an updated UCCJEA declaration either. From my experience, parties often move while a case is pending, and that is why in connection with the final judgment, the judgment form, the judgment form requires the filing of an updated UCCJEA declaration if there have been any changes. Brianna had John's former address in Texas. Dang it. Half of this email is blocked out. Something about UCCJEA declaration, period residency. I can't read that. There's no need to be so aggressive about it. Literally. Okay. Here she goes with her damn book again. Oh, no, this is Taylor. Oh, here's the whole email. Sorry, my bad, guys. Hi, Lindsay. I am contemplating filing a motion for sanctions against you at this point. Let's go, Taylor. Okay. Sorry, Sammy. I was too excited. I couldn't get there, girl. I was like, Okay. I am contemplating filing a motion for sanctions against you at this point. We didn't file an updated UCCJEA declaration. Neither have you, bitch. That's what she meant to say. She said, neither have you. But in my head, Taylor said, neither have you, bitch. Backspace, 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 backspace. And then continue, right? Okay. I don't appreciate your personal attacks. You don't need to be threatening or accusing me of being unwilling to answer for my failures to follow the law. It's not true. And it's petty and unnecessary. Bitch. Backspace, 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 backspace. Okay. Particularly when your hands are not clean to this issue. Your client has never filed an updated UCCJEA declaration either. And then it's from my experience. Okay. If you want me to file an updated UCCJEA declaration listing John's period of residency at his former Texas address and keeping his current address confidential in line with the DVROs, I'll do that. Just ask. There's no need to be so aggressive about it, bitch. Backspace, 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 period. She just kills me. Oh my God. Okay. Oh! She says, I'm unbothered by your threat, bitch. Backspace, backspace. If you feel you have a basis for your motion, you're welcome to file it. Oh, honey. Oh, out. Yes, out. It is getting juicy up in here, okay? Listen, next time we're going to skip the reading of all the shit. We're just going to get to the good stuff. We're just reading the emails here on out, honey. Okay? As explained in my last email, if you read the UCCJEA form, it's seeking residency history for the child, not the parent. Bitch, the child lives with the parent. What do you mean? What are you talking about? I wasn't Brianna's attorney for the... Hold on. Let me see if the next page has the whole email. No, it doesn't. Okay, part of this is blocked out. I did double check. I wasn't Brianna's attorney at the time of the 1024 step. Tell you what... I wasn't Brianna's attorney. Okay, tell me why Thomas didn't file one for her at that time. She was exercising her time there for a few months. Something about we weren't required to file one on the 525 move. Or something wasn't lived or hasn't lived in either of those residences because the orders haven't allowed Brianna to exercise her visits in California during this period. If/when Brianna's visitations is in California at her residence, we will certainly file an updated form at that time. I understand your experience / usual practice, but the CRC rule on this form requires it to be filed and served promptly following each residential move of the child involved in the case. This is why I shared the rule with you several emails ago, in case you weren't aware of this, or if you were unaware of this. I'm not being aggressive about anything. Attempting to discuss missteps taken in this case don't amount to aggression. Yeah, but you're being very aggressive. What do you mean? Okay, let me see. Go here. Oh my God, I'm gonna be quiet. It was here. Okay, this is the part. Sorry, Sammy. Hi, Lindsay. Oh no, this is from Taylor. Sorry. Wait, what the fuck is happening here? It says thank you, Lindsay. It literally says hi, Lindsay, and then thank you, Lindsay. Maybe this is two separate emails. I have no idea what's going on here. So this says hi, Lindsay. CCRC 5.52b. Both parties have the obligation to file updated UCC JEA if they learn of new information. You had an equal obligation to file upon receipt of updated information. The duty to update is shared equally by parties. It isn't limited to info about the party specifically. We both dropped the ball on this. This has nothing to do with either of the clients. Oh, there's two emails. Okay, thank you, Sammy. Sorry. I get excited, girl. I don't understand why this is even part of the case, because this has to do with the lawyers, not John Aubrey. Okay. We both dropped the ball on this. In any event, I filed an updated one, so it's no longer an issue. Well, Bree's getting ready to move again. Okay. And then she added, duty to update information in any action or proceedings involving custody of a minor child, a party has a continuing duty to inform the court if he or she obtains new further information, because we understand what all that's about. Okay, and this is the I'm bothered by the head threat. If you feel your basis motion, blah. As claimed in the last email, if you read the UCCJEA form, I'm seeking residency history for the child, not the parent. It wasn't Brianna's attorney. I wasn't Brianna's attorney at that time. The 1024 stip in order was entered, so I cannot tell you why Thomas didn't file one for her at that time with the content house address on it, as she was exercising her time there for a few months before the orders changed in 1025. We weren't required to file one in 525 move nor the 1225 move, as W hasn't lived in either of those houses. That's crazy though. So she hasn't even had W, and she's moved like 4 times. If and when Brianna visit, okay, I read the rest of that. Okay, now let me go up one more. This one was just that. It is. Oh, now I need to go back to where this starts, which is where. Oh no, I think we're done. Hold on. Okay, and then this is hold on. Hot flash. Hi, Lindsay. CCRC 5.525. Both parties have the obligation to file an updated UCC JEA if they learn of the new... Oh, I just read this one. The sanctions. Okay. The duty to update is shared equally on the parties. It isn't limited to info about the party specifically. We both dropped the ball. Okay, so I read that. Okay, so we're done with Breeze. Holy crap. Hold on. All of that, as I said, was Bree's docs. Now we have John's docs to do. I will get this uploaded tonight on TikTok. On TikTok. Oh my god, I'm on TikTok. On YT. I will upload this tonight. Can't wait for the... Thank you, Dylan. Can't wait for the video of Bri and Ruby sitting outside 2K's hotel. Yeah, that's gonna be good. Thank you, love. Take what your mama gave you. Thank you. Oh, get it down. Take what your mama gave you. I ain't got none back there. Oh, I forgot my water's in the freezer. Thank you, love. Very little about San Antonio. In what? In John stuff? D-Lon, thank you, love. Hold on, I gotta go get my water. Ugh. I got the new ones, guys. The Starburst watermelon. Whoa, almost fell. Bust my ass. Okay. All right, let's just dive in. It's 9 o'clock. John's are always short, sweet, to the point. I absolutely love it. Thank you, guys. I got my glasses off. And look, they got little, and I can see better. Okay, I can see. Got them off Amazon. Or the Zon. You know. Okay, here's John's. Petitioner's motion to strike respondent's reply. Brief to petitioner's March 16, 26 evidentiary hearing brief. That was live. Dylan, you're fine. Thank you so much, love. In what was just read. What do you mean? Yeah, because that's not part of it, love. Okay, let's not pin comments, guys, for a while, please. I want to get through the papers. She's not new, like not new. You mean like a new attorney? She's not a new attorney either. But I think she's newer to family law. She did a different kind of law. Ooh, this smells good. Mm-hmm. Okay. Hold on. Too much going on here. Oh, okay. I got you. Sorry, it's too hard for me to try to do comments and read this stuff all at the same time. But yeah, okay. All right, to the court and to respondent and her attorney of record, Petitioner John Giese, by and through his attorney of record, Taylor Budnick, we love her, Family Law Group, Inc., hereby moves to strike the respondent Brianna Lynn Olson's reply brief to petitioners January 16th evidentiary hearing brief in its entirety. He's going to throw the whole shit out. Get it out of here. Because of the following. No. Hey, love. Authority. 1. Respondent's reply brief fails to comply with the requirements established by California Rules of Court. California Rule of Court 5.111 governs the requirements of declarations supporting and responding to a request for court orders, Rule 5.11, whatever. A reply declaration must not exceed 5 pages in length unless the declaration is for an expert witness. I didn't know. The court grants permission to extend the length of declaration. Moreover, a declaration must be based on personal... Oh, hold on. Personal knowledge and explain how the... I gotta blow it up. How the person acquires that knowledge. The statement in the declaration must be admissible in evidence. Here, respondent is requesting a court order finding that she rebutted the Family Code Section 3044 presumption that an award of joint custody to her, a perpetrator of domestic violence. Did you hear that, Bri? A perpetrator of domestic violence. She said no. Is detrimental to the minor child's best interest. Respondent's counsel filed a reply brief that consists largely of statements which are not admissible in evidence and are not based on respondent's counsel's personal knowledge. Moreover, respondent's reply brief to petitioners March 16, 2026 Evidentiary hearing brief served on March 26, 2026. Respondent's reply brief, what, is 14 pages long, excluding attached exhibits. Respondent's reply brief is 21 pages. So all that shit that I just read, they want to throw out? I just read all that for nothing, maybe? That's okay. We had a good key. Is 14 pages long, excluding attached exhibits, making it 21 pages long, including exhibits. Okay. Respondent's reply brief should be stricken because it fails to comply with any of the aforementioned mandatory requirements. Amen. B. Respondent's reply brief is untimely and is based on new information not previously presented to the court or petitioner. Okay, Taylor. On January 6, 2026, the court was very clear that all documents needed to be submitted and provided to the other side by March 16th. Sure did. Respondent's reply brief was submitted just 6 days before the April 2nd hearing. You late. You late. Lindsay you was running your mouth, doing all that talking shit. You were worried about sending snarky ass emails. Thank you, Nancy. Snarky ass emails. Instead, you should have been making sure that shit was in on time, but you didn't. Because that shit didn't too late. Too long and too late. L&L. Loser and loser. Too long and too late. Sorry. Focus. Got you. Evidence, where was that? All documents and evidence to be used at the April 2nd evidentiary hearing. Respondent untimely filing is particularly egregious. Not egregious, Taylor. Not egregious. Okay. Egregious, given that the sole reason for the January 6th hearing had to be continued to April 2nd was due to respondent's failure to submit any declaration or evidence until the week before the January 6th hearing, thereby preventing petitioner for having an adequate opportunity to prepare for the hearing. And then you do it again. Thank you, Lord. Moreover, it appears respondent is now attempting to argue by raising the issue of the first time in her egregious and untimely? First time in her untimely reply brief that domestic violence is occurring in petitioner's home. This is an allegation that was never raised in respondent's declaration filed on December 31st, 2025, in support of her request to rebuke Family Code 3044. Presumption, or in any subsequent declaration filed by respondent as of the court's March 16th evidentiary hearing filing deadline. Petitioner's friends lacks the requisite relationship with respondent for any type of conduct by petitioner's friend towards respondent to constitute domestic violence. Amen. I don't even know what. Thank you, love, for saying that to send the heart means. I so appreciate that. What they're talking about. Both petitioner and petitioner's friend lack the requisite relationship with respondent's boyfriend for any type of conduct between any of these men to constitute domestic violence. Petitioner was not issued a DVRO because respondent's boyfriend threatened petitioner. Rather, petitioner was issued a DVRO because respondent personally and repetitively threatened petitioner. Finally, petitioner is not the party restrained by a DVRO and is allowed to or about respondent. Respondent's newfound argument that petitioner perpetrated domestic violence due to alleged comments he or his friend made about respondent or her boyfriend runs afoul. Egregious and afoul of the statutory definitions of domestic violence, and respondents vehemently listen. She's pulling out all the words, okay? Vehement defense of the first. I can see Lindsay right now. Shit, egregious? What? Hey, sorry, what's the definition of what's the definition? No, just kidding. Sorry. No. Shh. Sorry. I can see her now. Okay. Where's I at? There's the offense. Okay. A vehement defense of the First Amendment right to freedom of speech raised during the multi-day hearing to petitioner's request for the DVRO against her. This court ruled in favor of respondent when it came to narrowing the conduct that could support the issuance of a DVRO by precluding petitioner from presenting evidence about respondent's mean spirit through not overly threatening statements about petitioner on social media on First Amendment grounds. Amen, that did happen. I read it. This court agreed with respondent when characterizing petitioner's complaints about respondent's mean-spirited comments on social media as being primarily a complaint about defamation, stating repeatedly that defamation was not relevant to petitioner's DVRO request. It would be grossly inadequate for the court to now, thank you, love, now allow respondent to present any evidence consisting of the very same type of conduct that this court has already found cannot support the issuance of domestic violence or DVRO. Let me see if I can go skip to the next page. Nope. Oh, there we go. Yeah. In conclusion, again, she's short, sweet, to the point. I love it. In conclusion, based on the foregoing, petitioner respectfully requests that the court strike respondent's reply brief of March 26, 2026. So 10 days late, she turned it in. Petitioner's requested related to the exclusion of the evidence related to alleged statements by petitioner's friend or petitioner about respondent and or respondent's boyfriend is set forth in petitioner's motion to eliminate number 1, filed on March 19, 2026. Okay. And then we got, what is this? Oh, we got an amended list, y'all. We got Bree's docs in today in the John's response. Okay, number 28 is amended. Amended public Cookie! Thank you, love. I can't hear anything. Okay. Amended public records request and documents produced in connection therewith in reflecting calls for service to an address. Obviously, I'm not going to say the address. So they put in a FOIA request to get any and all calls to her address. Previous exhibit description, post. This is hard to read. Post depicting call logs to police respond, etc. So they put in the request for all those. Okay. So that's all of them, y'all. That is all of them. Listen. The call log list is, I don't know how to do Reddit. I have issues with Reddit. I love it. Taylor keeps it short, sweet, to the point. Big words. Keeps Lindsay on her toes. Yeah, the FOIAs will get you every time. My opinion on what's going to happen. I'm hoping that the judge. Okay, going backwards, right? I've always thought that this is where it would go, right? That W would move to Texas, stay with John. He would have full custody, and she would have some type of visitation. I've always said that. Now, the judge did concern me in some of the statements that she said last time. I've always been pro this judge, and I know that's always been kind of against what everyone else has always said. Everyone else has always really not liked the judge. But working in the court system long enough, I know judges will often give you enough rope. You know what I'm saying? Either succeed or don't. right? And I feel like that's what she did with BRI. So I was really counting on her to do that. And I felt that BRI did not succeed, right? She got enough rope to really herself. It's just a saying, TikTok, don't come for me. But when the judge said at the last papers I read, when she said, oh, you weren't pregnant when you assaulted Santos? Oh, well, that's not as bad. I thought you were still pregnant. I didn't know you were no longer pregnant with said child. That would have been a big difference. It was like, wait, what are you talking about? So it's acceptable to commit an act of DV when you're not pregnant? It's just an issue when you are pregnant? No, that's not how it works, Your Honor. So I was really upset, about that statement. But nonetheless, I think that it will still stay the same way. I think that it will be with John. In reality, BRI choosing to not go and see Baby W, I think, is a blessing in disguise. I don't think she really wants to see him anymore. She has her replacement child, per se. She's not even, really doing her calls. She states that. Yeah, or doing her FaceTime calls. I mean, now, granted, she doesn't have to come on and say every time she does a FaceTime call. But when she was asked, she was like, oh, no, I haven't been able to do them. She said, I don't know when they're scheduled, but she's like, I'm not really a morning person. What are you going to do with a newborn when your newborn gets up? Well, we know what you did with Baby W, but what are you going to do with your newborn? No, you guys, the April 2nd is only to determine, okay, the April 2nd is because BRI is asking for the DVRO to be dismissed and for her to have visitation of W in California. John is requesting the DVRO to be extended for 5 years. So that's what this is going to happen April 2nd. Then they have a trial in May or June. There you go, May 20th. Santo's still going to be up on it. Rhonda! What is that? What the heck? Rhonda be finding the coolest shit. Yeah, they can't move the case to Texas until the case is closed. Then it can be moved to Texas. But they have to fully complete it. Santo's like, no, I see. It will use alcohol to cope. So he is born. Yeah, I mean, if he didn't even stick around to his own child. And listen, I said this about the post they posted the other day. I can't believe I'm saying this. She's pregnant. I'm going to be a dad. You're going to be? Well, what the fuck have you been the last several years? I know, granted, absent, but you still shot the club up and a child came of that. Both of them don't even acknowledge or claim the kids that they already have here. And again, to me, I think this is so telling. And I don't know why someone didn't bring this up. Maybe they will next time. How at the last court hearing, in the beginning of the court, right, it was 3 to 4 hours. How come BRI was able to fly at the beginning of that court that day? The very beginning, she was able to travel. When she found out it wasn't going her way, suddenly she said on her own, I'm not, Rhonda! Oh my God, he's the coolest dude. Thank you, love. Call log is in my messages too. Oh, thank you, Riley. Then by the end of the thing, then all of a sudden she was high risk and she couldn't travel. Why was that? Why could she travel at the beginning? The very beginning of the court case that day, she said, for this month, which was January, for this month, I will fly both ways and pick him up and bring him back. That's what she said, right? Then the next 2 months, we can each fly one way until we have the next court thing. How come at the very beginning of that day, she was fine? Then she found out she wasn't going to get it. Then all of a sudden she was like, oh no, I can't travel at all. I'm forgoing my visits. She said, I'll have a FaceTime. How did she become high risk in that 3 hours? Yes, when I get there, love. I will show you, I promise. Because she's like a little kid who throws... Yes, Shannon, yes. She just throws tantrums because she didn't get it right. It's exactly what it was. It's exactly what it was. I really think Santos is a culprit of everything recently. Isn't John case going to be messed up because BRI didn't turn anything in? I figured that was evidence for him. Is it going to be messed up because he didn't turn it? She didn't turn it? No. Okay. Literally. Exactly. Beautifully flawed. Okay, let's see what Riley sent here. And then it's time for me to take some allergy medication.
Can someone tell me?
Okay, Riley. Oh, I'll take my Nikki. Oh, where's Nikki been? Oh my god, there's so many. Stop it. Where did you go, Riley? You were just there. Hold on. Okay. Okay, calls for service. God damn. That is a lot of calls for service to one address. And we're only talking about the for domestic violence. There's 1, 2, 3, 4, 5. There's 5 calls in 5 months. Every month. That's crazy work. And that's just what she's at this house. So there was a call 6/17/25 at 17:06 for domestic violence. 9/9. There was a call on 9/9 at 21:25 for domestic violence. 10/7. There was another call for domestic violence at 18:49. Then again on 10/28 at 19:30 for domestic violence. Then again just a couple days later on 11/2 at 12:18 for possible domestic violence. Then on 11/19 there's a battery investigation. Oh, then on 12/23/25 there's narcotic activity. Then on 1/28/26, oh, that just says radio. Jess, we will end up getting that because the officer is going to testify. I think I did read the statement, though. The statement just said that we got a call for a welfare check for a child, attended or, went to the house, whatever, made contact with the parties. I was able to get visual on the child. Child looked okay. Child's mother was not in attendance, and the child looked fine and healthy with the people he was. Yeah, so he'll definitely expand on. I have no idea, but that's crazy. From June 17th to November 2nd, 5 calls. And you guys, it may not even be them calling. A neighbor can call. I hope they get the police. Yeah, they will. Well, the officer's testifying. The officer's going to show up to the hearing on April 2nd and is going to testify. Yeah, other people can call. Speaking of, hold on, I'm so glad that came up. Because today, we were out and about. I was listening to 2 different, true crime cases. No, there's 3. 3 different true crime cases. And I have to ask you guys a question. Have you guys ever been in a situation where somebody didn't show up for work or church or at a doctor's appointment or something, and you instantly called the police because you were concerned about their whereabouts? Queen Day, hi love. I'm going to put it as a poll. So it's red, yes, blue, no. Have you ever, red, yes, blue, no. Have you ever called the police because someone didn't just show up to work on time or didn't show up to a doctor's appointment or whatever? Red, yes, blue, no. Because I'm like, am I just so nonchalant about shit? I've never done that. I've had staff not show up to work and not call me. I reach out to them, but I'm not calling the police and send them there. Maybe I should be, because in all 3 of these cases, they end up being solved or found quickly, or they're able to catch those person, because each one of the people, 2 didn't show up to work, and 1 didn't show up for a doctor's appointment, and the police were contacted. All 3 of the people were no longer with us, and they were able to catch the guy because it happened so fast. And then it made me think about the, what's his name? Why am I blanking his name? The one that, Watts, that unalived his wife and his 2 daughters and his unborn son. They caught him so quickly, and they found all 3 of the, 213, to 23, It's just such a random thing. But, Chris Watts. But they caught him because her friend showed up so quick because she didn't show up to the doctors. I'm like, am I just so like nonchalant about shit? I'm also not a people caller. I typically don't listen. I would if I needed to, but I typically just handle shit myself. I'm not one that just calls, don't call people. But nonetheless, that's crazy. So thank you, Riley, for sending that. Okay, that's me. I would just be over there just check. I put myself in all sorts of crazy ass situations. I just go handle stuff myself. Because they knew there was a back. Yeah, that's probably what it was. I cannot wait, Hannah. Listen, I don't know if I'm gonna be able to wait till May when I know she's gonna put it in there. I may have to just break down and get that one. It was because the friend knew. Yeah. Well, and not only that, and she knew in the Watts case, she knew that she had a doctor's appointment, and she knew she wasn't feeling good, and she had never missed a doctor's appointment. But I'm like, I can't imagine my employer just calling because I didn't show up one day. Was Mo 2K going to what? Was the welfare check on Christmas? Yeah, Christmas Day. I had a brand new puppy that cried and got a police call to the house saying I was being... No way. I had the police call me one time because the neighbor had dog shit in her yard and she thought it was my dog. That's what we're doing. It's so crazy. Well, it's out of their character. Yeah, I probably would. Yeah, I don't know. I've just never thought about it. And then all 3 of those cases today, I was like, dang, I gotta ask the SWAT gang what they would do. Rain. That's what I'm saying. Rain's good. Most businesses and stores are closed on Christmas Day, so where was she? That's a great question. A lot of people are trying to say that she was there. But I'm like, if she was there, why would she not have come out? It wouldn't have looked as bad. It's still going to look bad because you're not allowed to take them outside of Dallas and surrounding counties. But the fact that you put out the intention that you left him alone with randoms, and you can say random men or not, they're random to him. We're not saying random men that you're getting it in with. It's random men because he doesn't know them. I don't give a shit if it's Santos' family or not. He doesn't even know Santos. Shit, he doesn't even know you, lady. But nonetheless, that's a good question. Where the hell was she? I just don't know. Why would you... Oh, she has 3 warrants in Texas? That's why you think she'd want police activity? Well, listen, lose a child or... I don't know. Yes, Diane. Yes, those are from her address. They're a traffic. Oh, yeah, they're not arresting on a traffic ticket. No. No, they're not doing all that. Especially on that type of case, when there's an active DVRO, she has custody of the kid that cannot be around Santos, because they would have to take custody of the child, put the child into CPS custody, wait for John to get there. You know what I want to know, though? Yeah, she just pay the fines, millionaire. This is what I want to know. What would happen to the day that she... Rhonda, you're level 37. Thank you, love. What happened to the day that she had W. It was the first day she got him. And she sent a text message to Mama 2K and to John at 2-something in the morning, saying she had an emergency. She had to get back home. She needed them to come pick the child up immediately. Then hours later, message back and said, oh, never mind. And then they just never get to know what's going on. Again, that goes right back to John and Taylor's concern as to you have no support at all to help you. Like, what's going to happen in that situation in California? Have they been served on the... Oh, Pinky! Is there a new gift sale? Have they been served on them? No, that's postponed, love. Because she thought that... Is that why she had to go? Because she thought that... She texted 2K, Mama 2K and 2K at 2 o'clock in the morning because she thought Santos was cheating. Wow. That's crazy. Because Santos was cheating. BRI had cameras in the apartment. Oh, is that when he was with Valet? Wow. I wouldn't put it past her either. Again, that's the true reason why she doesn't want to be alone. She doesn't want him to not go. Yeah, she was in Texas. He was in California. My understanding, Caitlin, I think from, if I remember correctly, when I read his statement, he did ask for BRI. I was told she wasn't there. Then you pull a timestamp on when her and Santos went to drop off gifts to see the police cam. That would be a good idea too. Crazy. She's never been... Thank you, Mama! Listen, I love every single gift I get, but whenever somebody sends their very first gift ever on TikTok to me, that's always extra special. Thank you so much, love. She's never been alone at any of her visits. Ruby went with her, and then her mod and her mom. Yeah. That's what cracks me up when she says that she has no help. She does it all by herself. She's never been alone with the child. Stop it. Stop it. So, okay, guys. Well, if we want this up over on the YT, I got to hop off. Plus, I got to take some allergy medication. These stupid flowers. Her mod, yeah. Her mod's the one that does all of her, schedules all of her, she calls her assistant too. Again, if you're not making any money, why do you need an assistant? You're not working, you're not doing anything, you have no money according to you. Why need an assistant? But anyways, when she is alone, she sits in the house and does nothing. Thank you, Kat. Of course, she was insecure. Another one. Thank you so much, love. Of course, she was insecure about Emily. Emily is stunningly beautiful. Stunningly beautiful. Yeah. Oh, thank you, Al. Calm down, Yolanda. Breaking down the court documents in the Brianna and Santos case. Al, get it together. Get it together, Al. Hey, Boxer Mom. I probably shouldn't have beds. Why would anyone be an unpaid assistant? Look, we're trying to figure that out too, honey. Okay, the Lord's work, amen. We are trying to figure that out too. She even has her to where she's using her account for Snapchat or whatever it's called. She's using her account for that. Which means there's income coming in. And she'll have to pay taxes on it. The whole thing it's a weird thing. You're welcome to know. Alright, guys. Well, I'm going to hop off so I can download this because this is long, so it's going to take a while. I will get up. Do you guys like when I get it up for those of you guys that came in late? Do you guys like when I post in my thought box that it's up or no? That doesn't matter. Those who make themselves look so... Literally, they really, really do look so stupid. Yeah. You guys do like it? Okay. So I will do that as soon as I get it posted because it takes a while. I'll put it in my thought box. I'll stay up till it's done. I got y'all. I love y'all so much. Thanks for always coming over here and hanging out. If you're not already following, please make sure you follow. Okay? We are on a road to 100K. We got to get there. So I will see you guys tomorrow. And I will go download right now. Love you guys. Have a good night. Bye.